Some couple of seats here. Can you come forward, ladies and gentlemen at the back? Please come. You have to have the courage of your conviction that you are a smart person. That's why you came early. Please come and sit in front. I want to start by painting a scenario, and anybody can please come in and interject. Let us assume that we're all lawyers in this room, and a client comes to us and says that a transaction is coming up. Can you draft this agreement for me? And we all know that the Arbitration and Mediation Act is the governing law of arbitration in Nigeria. So I want to ask anybody, what would be the first thing you will do? Anybody. The Arbitration and Mediation Act is the governing law for arbitration and mediation in Nigeria. What's the first thing you will do as a lawyer? Well, let me fast forward. You go into the law and you read about the appointment of an arbitrator. Would anybody do anything different? All the people who are responding are shaking their head. You just go straight into that document and see what did they say about the number of arbitrators. That's number one. The second scenario I'd like to paint is someone comes to you and says that the chairman of the Chartered Institute of Arbitrators Ibadan branch owes him money from a transaction that is done with him, and he wants to go to court. You ask, let me see the agreement. You see the agreement. You see an arbitration clause. And you say, no, you can't go to court. You must go for arbitration. And you read it and you see that the Arbitration and Mediation Act is the governing law for that arbitral process. What would you do? What's the step you will take? You will go into the Arbitration and Mediation Act, and the first thing you are going to read is, what is the arbitral procedure? What am I supposed to do? Now, those are things we will do naturally. So I want us to step out of that natural space, because what I'm about to talk about, which is the foundation of this new law, the provisions I'm going to be talking about are not in the Arbitration and Conciliation Act. But if you want to practice arbitration and be taken seriously, not only in the domestic space, but also internationally, you need to understand the basis, the foundation of the Arbitration and Mediation Act. So, the first point I said is that both the former law and the current law are predicated on two model laws set up by UNCITRAL. And that is the International Commercial Arbitration Model Law of 1985 with amendments adopted in 2006. Then the International Commercial Mediation and International Settlement Agreements resulting from Mediation 2018. Now, what are these model laws? When I looked at the time I was given, I said, this is unfair. I can talk about this topic for the next 2 hours straight. But I'll try to be as brief as possible. These model laws are designed to be adopted by nations who want to formulate their own arbitration laws. What UNCITRAL realized is that different countries come up with different laws, and there's no uniformity that can be adopted by international businessmen when they have disputes, and it goes to arbitration. So they set up what we called working groups, and the members of the working groups are taken from all over the world. So England will come to the meeting of the working groups with their own position on certain aspects of arbitration. US would also come with its own position. The representatives of Paris would come. The representatives of Nigeria would come with their own positions, and they hold these meetings until they arrive at consensus provisions that are acceptable to all of them. So it is like a form of negotiation. So the documents we have in our hands is predicated on the UNCITRAL, these two UNCITRAL model laws, which is universally accepted. And why is it universally accepted? To a businessman coming to Nigeria, once he sees that your arbitration law is predicated on UNCITRAL model law, it gives him the comfort that he's not dealing with a local law. It is a law that has been put together by the international community. So when you see some of the provisions in that law, the tendency is that you are going to assume that, oh, this is just a group of people, committee members, a committee, national committee chaired by Mrs. Fumi Roberts, who just came up with whatever they liked, thought would suit Nigeria. No. This is a law based on international standards. So a country that has 70% of the provisions of its laws based on the UNCITRAL model laws is called a model law country. Now, not all countries have predicated their arbitration and mediation laws on UNCITRAL, because some of them pick UNCITRAL, but they pick perhaps just 10% or 20%. Those are not UNCITRAL countries. But when Nigeria, if you look at that act, if you go online and check the UNCITRAL model law, you will find that 70% of the provisions of this law come from those two model laws. Next slide, please. Now, why did we need to reform the ACA? We're all familiar with the ACA. It was decreed into law in 1988. We've been using it. But there are so many reasons why we needed to amend that law. When Chief Bayo Ojo was the Federal Attorney General of the Federation, he set up a 15-man committee headed by late Dr. Orojo, and we called that committee Orojo Committee. The 15-man committee met and they identified the reasons why we needed to change the Arbitration and Conciliation Act. Now, the most profound part of what they said, and which still rang true until May this year when this new law came into being, is that it is clear that the legislation has not achieved the objectives that inspired its enactment. The ACA has failed to achieve one of the underlying philosophies of the UNCITRAL model law. In Nigeria, arbitration is often perceived as the first step to litigation, and the arbitral process often becomes entangled in the extremely protracted and cumbersome litigation regime in Nigeria. Who disagrees? Does anybody disagree with that? Any practitioner would agree that even though this statement was made many years ago, it still rings through today. And that is why we had to go back into that historical detail and find out, as the position changed, and we realized that no, it has not changed, and it has even become worse. So at the back of our minds, when we were coming up, crafting this law, are some of these things, and those are the things that informed some of the provisions of that law. Now, what is the structure of this new law? It's divided into three parts. The part one deals with arbitration, then mediation, and the miscellaneous provisions. Next slide. Now, if you read section 1 of that law, and this is not in ACA, it highlights what are the objectives what do we hope to achieve in this new law? And why is it important for us to understand that? The only way we can make this law a successful law, such that non-Nigerians can make it the governing law of the arbitral agreements, is if we understand and keep faith with these objectives. A couple of weeks ago, we were negotiating an international contract. No, it's several months now, in my law firm, and our managing partner was in London for that transaction, and it was like, oh, we wanted the English Arbitration Act to be the governing law. It was a battle. It was a tug of war. Because this contract, one of the major parties is Nigerian. The contract is going to be implemented in Nigeria. Why do we want Arbitration Act of England? And one of the things that threw back at us is that you have an antiquated law governing arbitration in Nigeria. So one of the things we then did was we delayed the negotiation of the dispute resolution clause. I had known that that law was going to be passed, even if it was the last day Buhari was going to be in office. So we delayed it, and we kept dealing with all the commercial provisions of that agreement until that law was passed. Then we said, now we are ready to negotiate the dispute resolution clause. Why? Because we don't want this law to be localized. We want it to be a law that can be used as the governing law of arbitration in any arbitral process, in any transaction, any dispute that arises from any transaction globally. So, there are 4 objectives this law is meant to achieve. And this law, if you read the provisions of the law, these 4 objectives underpin practically all the provisions of that law. And that is why whenever we have this kind of symposium, I always say that we must start by telling people, because like when we started, I asked you what would be the first thing you did. Nobody would go and read these provisions. They will just go straight to the provisions that they are interested in to resolve the particular transaction. But we will be missing out on the significance of those provisions if we don't understand these objectives. The number one objective, and the best way to evaluate a law, is to look at the objectives, look at the way it is being implemented, and ask yourself, have these objectives been realized? But if the objectives are not articulated, there's no way you can benchmark the success or otherwise of that law. Next slide, please. The first one, to promote fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. Number one objective. And this objective underpins one of the main benefits of arbitration. We don't want to go to court because it takes like forever. So let us go for arbitration. But we now find arbitral processes that run for years. So what we are saying is that all these provisions in this law must take cognizance of the need to promote fair resolution of disputes by an impartial tribunal without delay or expense. Number 2 is disputing parties are at liberty to decide their dispute resolution process, provided they adhere to measures that are to promote peaceful existence and protect public interest. Why do we have mediation there? We all know the benefits of mediation. We don't want to live or thrive. I don't even see any country thrive in an adversarial space. So that is the second objective. The third objective is, unless parties agree otherwise or the arbitration agreement is void, an arbitration agreement shall be binding to the exclusion of any other dispute resolution mechanism. That is the third objective. The fourth objective is parties, arbitrators, arbitral institutions, appointing authorities, and the courts shall do all things necessary for the proper and expeditious conduct of arbitral proceedings. Those four. And I'm appealing to you, have this, when you are interpreting this law, when you are advising your clients, you must have these four objectives at the back of your minds. If I were a magician, you would say Mrs. Roberts is a magician. I had told you that my Lord, the Chief Judge of Oyo State, is going to grace this occasion. Can we give her a round? And she's not going to explain why she came late. I can make that explanation on her behalf. Because it is the members of the bar that kept her in the office, and that is why she is late. But we are appreciative of the fact that you have joined us, my Lord. Thank you very much for your presence. Now, if you look at the Arbitration and Conciliation Act, it has provisions for domestic arbitration. It has provisions for international arbitrations. And we said no. We want a law that is like the law of arbitration in England, the law of arbitration in any developed economy, so that this law can be applied to any type of arbitration, whether domestic arbitration or international arbitration. And that is why I tell my mentees in arbitration, you are the one going to determine what type of arbitrator you want to be. Do you want to be a local arbitrator or do you want to be international? If you want to be international, you must read this law. I want to thank the members of the Chartered Institute of Arbitrators, Ibadan chapter, for making this available to us. And I think they deserve a round of applause for that. Please, put it beside you and read it. Those of us who are transactional lawyers should also read it. Judges in our midst should read it. And I say judges in our midst should read it because lawyers who have not read it are going to come before you and try to pull wool over your eyes. So if you have read it yourself, you'll be able to challenge them. And I'm sure one or two of you know what I'm talking about. So this law applies to commercial arbitrations, whether international, whether domestic, whether between states, as defined in Section 91. Section 91 is the definition provision for the law. And it is applicable where the juridical seat of the arbitration is Nigeria. I don't want to go into that because if I were to talk about the meaning of juridical seat, we are going to be here for the next 1 hour. So this law, if parties in China and Namibia decide that the juridical seat of the arbitration is Nigeria, this is the applicable law. So it also applies, there are certain provisions of that law that apply whether the seat is Nigeria or not, whether the parties have designated the seat or not, whether the court has determined the seat or not. The Nigerian courts can assume power as long as an application is brought before them. It does not matter whether the seat of that arbitration is in Nigeria. They can assume power in 7 instances, no matter where the arbitral juridical seat is. And this seat, I'm not talking to Isaiah. I thought I had my slides up there. They can stay court proceedings. If one of the parties have brought court proceedings, they have the power to stay court proceedings, even if the seat of that arbitration is not in Nigeria. They have the power to grant interim measures of protection, whether the seat of the arbitral process is in Nigeria or not. They can recognize and enforce interim measures. They can refuse recognition and enforcement of interim measures. They can issue subpoena to secure the attendance of any witness. They can recognize and enforce awards. And they can refuse recognition and enforcement of awards. It is a very, very powerful provision. And it is a provision that the advantage of which is in the hands of anybody. And I am bringing this up because we will not read it. So the provisions that I'm talking about are provisions that we may not read, but which would impact on our work. But because we have not read it, we may not know and enable our clients to take advantage of those provisions. Now, on several occasions, soon after the law was passed, several people called me, I'm in an arbitration, or I'm about to start an arbitral process. Am I going to be governed by this new law? If your arbitration had commenced before 26th of May, no. Unless parties decide to amend their dispute resolution clause and decide to adopt the AMA. And that means that you have to go and read the ACA and find out when does arbitration commence. And it commences when you issue your notice of arbitration. Once you have issued your notice of arbitration, then the ACA apply. Now, if any right had accrued to you under the ACA, or if any liability or privilege have accrued under the ACA, the fact of the repeal does not affect those rights. And that is important. Can we go to the next slide, please? Everyone in this room is interested in arbitration. That means that we are all stakeholders. The businessmen we serve are stakeholders. Our colleagues are stakeholders. The members of the bench are stakeholders. And the reason why I am bringing this up is the fact that, unlike the ACA, this law gives a mandate, several mandates to all stakeholders, that when you are interpreting this law, you must remember its international origin. And the reason why this is important, I keep reiterating it, is that we don't want this to be seen as a domestic law. We want the Koreans to see this as a law that they can rely on. We want the Europeans, we want the Americans, and we, all stakeholders, are the ones going to promote this for the benefit of our country. And why do I say this? Many people don't understand the effect on dispute resolution on the GDP of any country. If you read, I'll try and see if I can find that article. The contribution of dispute resolution to the GDP of Singapore is almost 40%. And why? Because Singapore is now one of the most favorable seats for arbitration globally. And that is what we are trying to achieve in Nigeria. And the starting point is to have a law that is internationally recognized. The second thing is that we need to promote uniformity in its application. When you see some judgments from the Federal High Court, we are in a country where there are different layers of courts. Even Supreme Court disagrees with itself at times. Courts of appeal, not to talk of Federal High Court, and in fact there are a plethora of them. So we are hoping that in the course of time there will be uniformity, because more and more people are now interested in arbitration. And I want to thank the organizers of this symposium for bringing our students in. Last week I was having a conversation at the first late Professor Mark Bogunje's annual lecture. And we were talking about the fact that in Nigeria, we are still very much focused on litigation. And I said the trend is changing. There is no university in Nigeria today that does not have ADR. society amongst their students. If we older lawyers don't jump on the train, these young ones are going to take over from us. They are not interested in litigation. They are more interested in arbitration and other ADR mechanisms. So I congratulate you, students, for being a part of this symposium. Please, can we go back to the slide before? The need to observe good faith. It is critical, and this message is particularly targeted at us lawyers. And I'll give you just one example. Now, at a preliminary meeting, I'd seen the notice of arbitration, and I realized that it didn't conform fully with the law. But the thing about party autonomy, which I'm going to, principle of party autonomy, is that parties are allowed to change anything they want. So I asked the parties, respondent, the counsel from respondent from a reputable law firm, I asked them, look, you are pointing out that this notice of arbitration is defective. Okay, can we overlook it and you adopt it as being fine? They said no. Why? Because they wanted to delay the process. And because of that defect, we had to stop the arbitral process. 9 months down the line, I got a call. I was in London and it was like, Mrs. Roberts, we think we are now ready for that arbitration. I said, unfortunately, Mrs. Roberts is not ready for that arbitration. And I turned it down because that was evidence of bad faith. Under the principle of party autonomy, there's nothing that you have written down that the parties cannot decide to change. So if you observe good faith, okay, they just missed out simple, inconsequential things from the notice of arbitration. We are ready to accept it as binding on us. That is an exhibition of good faith. Now, the final is that recourse may be had to the travel preparators of these two model laws. Can we go to the next slide? Before I became the chairman of the committee that came with this law, I'd heard of travel preparators. I had never read it before. For me, it is too much of a trouble. Until Professor Idonije, the chairman of the technical committee, and incidentally, one of the speakers for today, Mr. Isaiah Bozimo, SCN designate, is also a member of the technical committee, called me one day and said, Fumi, have you read the travel preparators? I said, yes. I said, no, I had not read it. He said, you cannot be my chairman if you have not read it. I read it in 1 week. Because when Professor Odonije says you do something, you say, yes, sir. I read it and I was blessed for reading it. And what is a travel preparators? I'll choose one of the simplest definitions. It is, they are the official record of a negotiation useful in clarifying the intentions of a treaty or other instrument. It records the negotiations that took place in regard to each provision of the model laws until a compromise is reached in regard to that provision. I'll take you back to where I started when I said that these model laws were formed by representatives from different countries from all over the world who form the working group, who come with their country's respective positions. They get to the UNCITRAL headquarters and they begin to articulate their position. They begin to negotiate until they arrive at a consensus. So if you read any provision of this law and you want to understand how 54 countries arrived at that provision, read the travel preparators. I don't know whether what I'm saying, if anybody has any questions about it, it is one of the best things I've done in my life, in my journey in arbitration, that I read the travel preparators of the model law on arbitration and the model law on, it will practically simplify your understanding of that provision. And incidentally, the travel preparatories of those two model laws are online. So you have easy access to them. Just Google travel preparatories for UNCITRAL model law on arbitration, and it will bring it up for you. Next slide, please. Now, this, I don't know, sorry, let me see whether, now, let us say that a dispute had crystallized. Your notice of arbitration, in the old law, it was notice of arbitration. But now we call it written communication requesting arbitration. Why? Because of that kind of scenario that we said. So an ordinary email will do. No formality about it. No, they did not write it in a particular way. No. And remember the objective. The objective is to move quickly, as efficiently as possible, and not be bogged down by technicalities. So, in the old law, there are two provisions that were in conflict, Section 45 and Sections 5 and 4. One of them says, the court shall refer the parties back, shall stay proceedings. The other is discretionary. And it gave rise to a lot of litigation, unnecessarily, in my own opinion. But in the current Section 5, when the court comes across a dispute resolution clause that includes arbitration, it is not that it may, it shall stay the proceedings. Now, in the old law, also in conformity with the need to save costs, if in your dispute resolution clause you did not put the number of arbitrators, before it used to be 3. Right now it is 1. And then the default appointers of arbitrators. Now, in your dispute resolution clause, a smart lawyer will put, if the parties are unable to agree on who the arbitrator should be, it is the court that will be the appointing authority. As I stand before you, I've been appointed by a state government 4 years ago. The other party went to court. They've been in court for 4 years here in Ibadan. Only for the judge, one lawyer is smiling. He knows what I'm talking about. The case has been before one judge for 4 years just to appoint the arbitrator. So what did we do? We said no. Let us expand the scope of who can be the appointing authority. So in your dispute resolution clause, please always put the default appointer. Your default appointer can be the Chartered Institute of Arbitrators, Nigeria branch. It can be the multi-door courthouse, but it is critical. And then, now, in that scenario that I was talking about, they took an application to court. They did motion. They did affidavit. They are still in court 4 years down the line. That is not how to get the court to appoint. If you go to the Federal High Court, if you go to some state high courts, all you need to do is to write a letter to the chief judge to appoint, and the chief judge would appoint. So in this law, we have said that the court, for the purposes of appointment, is the chief judge sitting in chambers. So she gets your letter, she looks at it, maybe she consults 1 or 2 people, or she consults and appoints. And our appointment is binding. So it is not by way of motion, way of application, originating. So I don't know all those terminologies. It's been a long time since. And if you are not careful, if it is an international arbitration, the default appointer is the Director General of the Regional Center for International Commercial Arbitration. And what have you done? You've taken the power of appointment away from the parties and given it to somebody who doesn't know the parties. Party autonomy, I've used that phrase several times. And in this law, you will find that phrase exemplified in phrases such as unless the parties agree otherwise. The parties are free to agree, subject to a contrary agreement by the parties. Parties may agree. Please, this provision occurs in, there are 90-something sections of the new law. These phrases occur in 60 sections of the law. And what does that tell us? The control of the arbitral process is in the hands of the parties. But most of our clients don't know arbitration. They rely on us. They rely on us to craft a dispute resolution clause that works for them. But what do? We just say, it shall be by arbitration under the Arbitration and Conciliation or Mediation Act 2004, and that is it. And what have we done? We have deprived our clients of the power given to them under this law to be the ones to determine issues like the number of arbitrators they want, who their appointing authority would be. 59 provisions or 60 provisions of the law put the power in the hands of the parties through their lawyers. And what did I do for myself personally? I copied out all the provisions of that law that gives. So anytime we are drafting, Bukola has it. She's one of our transactional lawyers. Anytime we are drafting a dispute resolution clause, we are looking at those provisions and saying, oh, let us ask the parties. So you will not find a dispute resolution in Nigeria of today, in the current world we live in, where we have global transactions, where we have a borderless world. Your dispute resolution, if it is less than half a page, you have not done justice to the parties. If you have a dispute resolution clause that takes just 5 lines, you are making a mistake. Because in your dispute resolution clause, you can say that if you say that the parties shall agree after the dispute has arisen, they will never agree. And I see so many dispute resolution clauses like that. The best time to get the parties to agree is when they are negotiating the commercial terms. And don't wake up in the middle, oh, I forgot to put a dispute resolution clause, and you quickly draft something. You are not being fair to the parties. You will determine the seats because it is within the powers of the parties to determine the seats, to determine the governing law, to even go as far as determining the venue, to determining who would appoint if they are unable to appoint, and so many other provisions like that. So my recommendation to you, many people are going to ask me, Mrs. Roberts, can I have that list? Bukola, don't share that list with anybody. Please pick up that law and read the law. You will be doing a great disservice because this law is full of fantastic gifts to our clients. Let us seize the opportunity. Let us use this opportunity because the principle of party autonomy is trying to okay. I don't want to even start in this part because I know my time is up, right? Yes. So I can take this at another symposium so we don't have to worry. Because I was making a case here for concurrent proceedings. And please just give me 2 minutes to say this. 5 years ago, if I were making this presentation, I'll say, have multi-tier dispute resolution clauses. The world has moved away from there. What the world is now talking about is concurrent arbitration and mediation clauses. And what does that mean? Mediation will be going on at the same time as arbitration. And in America, and I think LASIAC is about to come up with their own concurrent proceedings procedure now. That is the way the world is going. Businessmen don't want to be caught up in court. So if they can resolve the dispute, even while the arbitration is going on, all they then need to do, if the mediation works, is for them to go to the arbitrators and say that we have settled, enter this as settlement award, and you are bound by it. So it is now mediation running the same path as arbitration. Please go online, read. There are thousands of articles on it. That is the way the world is going. And about a month ago, the ICC itself, the International Chamber of Commerce, brought out its own protocol for facilitating settlement during arbitration. Why? Because there was a clamor from the business world. Arbitration is becoming too expensive. We don't want to stay too long in court. We want you to craft a situation where we can resolve our disputes even though we have arbitration clauses. I thank you all very much for listening to me.
Please let's give her another round of applause. We thank you very much. We've not been fair to you. Ordinarily, this is a topic she would have loved to have 1 hour or more. But we are constrained with time. We are happy you indulged us, notwithstanding. And I think we will change the timekeeper. I won't say anything further. You agree? So thank you, Mrs. Roberts. And I think the topic that has been handled has given us a further insight into the current position. As she was making some comments about clauses, somebody sitting in front was now looking at me because we had a contract and he was suggesting some things to be inserted as arbitration clause. I won't say anything further. No, I oppressed him. I said, no, I'm not agreeing with this. But that's on a lighter note. But we want to thank you for the well-captured topic. The SCN designates, you're online now. We'll now move to the next topic, and after this topic, we then have opportunity to ask questions and comments. But before you start, let me formally welcome the Honorable Chief Judge of Oyo State, who came into our midst. We thank you for honoring our invitation, and Honorable Justice Lajide, thank you. I saw some. Honorable Justice Adeyo, I welcome you. Thank you very much. Learned senior advocates that came, I saw some of you seated already. You are recognized and most welcome. Thank you, Justice Adeyo. So the second lecture will be, or the presentation by Isaiah Bozimo, who is online. It will be on arbitral procedure. You have 30 minutes. Thank you very much.
Next intervention regarding arbitral proceeding. I'll try and be as efficient as I can, and I hope that the network is accommodating and you can both see and hear me clearly, and also see the slides I'm presenting. So my intervention will focus mainly on procedural aspects. AMA, where you can now have ex parte communication between a party and a tribunal. And because it's ex parte, naturally the tribunal is very wary. So when they make a preliminary order, it lasts for a very short time. It will expire after 20 days. It is binding on the parties, but it's not subject to court enforcement. But as we'll see later on, there are ways for the tribunal to ensure compliance. And we'll see that when we discuss things like peremptory measures or measures the tribunals can can use to enforce party compliance with their respective orders. The tribunal can modify it again, so it's very malleable. And the purpose here is really to ensure that the subject matter of the dispute remains intact. So, for instance, there is no risk that assets will be dissipated. There is no risk that the subject matter of the arbitration will be moved from one jurisdiction to another, and so on and so forth. So if we can move on to the next slide, please. Okay, so now we discuss the issue of consolidation and joinder of parties. Now, this will typically arise where you have a multi-party or a multi-contract scenario. Very interesting set of provisions. Was not envisaged in the Arbitration and Conciliation Act, but it is now increasingly common because of the complex nature of international business. Very frequently, you will have contracts that have more than one party. So, for instance, imagine a consortium agreement where a consortium comes together to bid for a big project. Or imagine a big construction project where you have a main contract, a subcontract, and a sub-subcontract. So in those situations, you have either a multi-party dispute or a multi-contract dispute. And with that, there is a risk of parallel proceedings. So for instance, if it's a multi-contract dispute, you might have a dispute under the main contract and a dispute under the subcontract that relate to the same project. Now, imagine if you allow both of them to continue in a parallel nature, you might have irreconcilable decisions. So the arbitration under the main contract can reach one decision, whereas the one under the subcontract can reach the totally opposite decision. So you will be working at cross purposes. Now, in situations like that, you can make an application to consolidate the two proceedings. So you have one decision that binds multiple contractual arrangements because there is a nexus of facts or a nexus of parties. Likewise, the issue of joinder. Now, if we go back to the example of a consortium agreement, we can move on to the next slide, please. If you look at the example of a consortium agreement, you might have several parties, but each of those parties is bound by that same agreement. So technically speaking, you don't need to have a joinder there. Now, what happens where, for instance, you have a consortium agreement? Under that consortium agreement, they agree to form a special purpose vehicle, a company. And the company is now controlling several assets, including payment of particular parties. Now, let's say one of the consortium members is unhappy with the arrangement and now comments arbitration under the consortium agreement, but wants to join SPV as SPV is not about join it to the arbitration agreement recommend to you also exactly what happened in that situation. Okay, I think we're connected back to our hosts in Ibadan, so I will continue. Okay, I think we're back on with the hosts in Ibadan. So thanks again. I hope everyone in Ibadan can hear me clearly. So I will continue in the hope that that is the case. The issue of awarding interest, again, a new provision in the arbitration mediation beginning to end, the four goes.
In areas where the court will intervene. Mrs. Roberts has touched on many of them, and I must also give kudos to her for the work our committee did in bringing out this act. We really commend you, Mrs. Roberts. We are very proud of you in Ibadan here, and you continue to be a beacon of hope when it comes to arbitration. Thank you very much. I want to quickly start with section 1.6. I've been limited to the section relating to court, but I want to start with section 1.6. Please go to this slide. Leave out the introduction. Ms. Robert has touched it. Please go to the next one. Yes, section 1.6. The section 1.6 says, the provision of this part shall apply where the seat of the arbitration is in the territory of the Federal Republic of Nigeria. For the benefit of the students here, the seat is what Redfern describes as the legal center of gravity. When you choose you are drafting your arbitration clause, you choose the seat. And that seat will determine the applicable law. So if you are choosing Nigeria, any state or anywhere in Nigeria, that means the seat is Nigeria, and Arbitration and Mediation Act will apply. But that is different from venue or sitting. You can choose the seat in Nigeria and decide to go and sit in Singapore. Even if you sit in China or Singapore or UK, the law that will still be applicable is Arbitration and Mediation Act. I just said that because I can see we have students here. So this act has chosen is applicable where the seat is in the Federal Republic of Nigeria. That would take us to section 1.7, which Mrs. Robert alluded to. It's a very beautiful part of this new act. Ordinarily, where the seat is not in Nigeria, the court should not have anything to do with such arbitration. But by section 1.7, everything has changed. And I want to read out that section 1.7. Says, the powers of the court under this section shall apply even where the seat of arbitration is outside the Federal Republic of Nigeria, or the parties have not designated the seat, or no seat has been determined. So, if the seat of arbitration is in UK, in US, in China, and you need to obtain an order in court for certain areas which we are going to mention now, nobody can say, no, you can't make order in Nigerian court. My Lord, the CJ can make order, even where the seat is not in Nigeria, as in this area. And if you go to that section 1.7, one of it is relating to section 5, which is to stay court proceedings. And in staying court proceeding, there is also a clause there that the court can make interim or supplementary order. We are going to get to that. Another area where the court can make order, even though the seat is not in Nigeria, is power of court to grant interim measure of protection. That has been said here. And one beautiful development in this section is that rather than that measure application to grant interim measure being in court indefinitely, the new act says that order should be granted within 15 days. It has to be granted within 15 days. Another section where the court can make order even though the seat is not in Nigeria, is for recognition and enforcement of interim measure. If you obtain an interim measure from an arbitration proceeding in UK, in US, you can come here and ask the court here to recognize and enforce it. Same thing is also to refuse to recognize and enforce. Just the other way too. But another clause there under that subsection is that even though the court is refusing, the court can reformulate the order in the interest of justice. We may also get there if we have the time. Also, whether the seat is in Nigeria or not in Nigeria, the court can make an order to secure attendance of witnesses. And areas on that will also get there. And also recognition and enforcement of award, as well as refusing recognition and enforcement of award. So if you look at it, just like Mrs. Roberts says, about 8 items under that section 1.7, where the court can make order whether or not the seat is in Nigeria or not. Next slide, please. Now, I want to discuss section 5 of the Act. If you have, that's the power to stay court proceeding. That section, in the old Act, we used to have sections 4 and 5. And there were a lot of controversies as to the power of court. One section used may, another one used shall to stay proceeding. But that has been clarified now because the new section 5.1 of the Arbitration and Mediation Act uses the word shall. So the court does not have discretion. Once a party brings it to the notice of the court that the matter before the court has arbitration clause, and ordinarily they should proceed to arbitration, the court shall grant a stay of court of proceedings, except if the arbitration agreement is void, inoperative, and incapable of being performed. That's the only exception where the court can decide not to grant stay of proceedings. So it's mandatory. Next slide, please. Now we look at section 17. And that is where we are now discussing in full detail those areas we mentioned in section 1, subsection 7. That's power of court where the seat is not in Nigeria. We have already discussed section 5. We are now on interim measure, which has also been mentioned. We said the court has power to grant interim measure within and outside Nigeria. And it has to be done within 15 days. It refers to third schedule of the Act, which we are going to discuss in extensive during this discussion. Please, next slide, please. We also discuss recognition and enforcement of interim measure, that the court can grant, has power to grant interim measure, and what interim measures are, why they are granted, we also stated it there. I'm not going to spend time on this because Mrs. Roberts and my brother Isaiah mentioned this. They are just meant to maintain status quo and to preserve evidence. Then same thing with refusing recognition and enforcement of interim measure. On what ground can the court refuse to grant interim measure? These are set out in section 58, subsection 2 of the Act. And examples are incapacity of a party, invalidity of the arbitration agreement, and also incompatibility. Those are reasons why the court can refuse it. Next slide, please. Also, whether or not, like we mentioned, whether or not the seat in Nigeria, the court can also grant an order to secure the attendance of witnesses. In what areas can the court make such an order? It can be to compel the attendance of witnesses, either by subpoena duces tecum or subpoena ad testificandum. So court can make such an order. And it does not matter whether the seat is in Nigeria or not, like we earlier mentioned. The other one is recognition and enforcement of award. We all know that an award that cannot be enforced is useless. And that's one of the reasons why we said arbitration needs court. The court does not need arbitration. So whichever way, whether we like it or not, the award may find its way to court. And the court has power to enforce it, irrespective of which seat. And then it's an opportunity for a successful party to reap the benefit of the award. Next slide, please. So, the other way, on the other hand, the court can also refuse recognition and enforcement. So, these are the area which we mentioned where the court can refuse or generally make an order. So, let's now go to the next slide, which is the very important one, which I know concerns my work here. And that is, for the first time, we now have rules that will govern this act. And it's very important for our courts to be familiar with these rules, because it's a third schedule of the Act. Is there? I will just highlight certain part of that rules for our benefit. The first area I want to highlight is Rule 6. Rule 6 says the court may order that an arbitration can be had either in public or in private. I'm sure my lawyers will be wondering, how is this possible? But that's what the rule provides for. Arbitration claim can be had either in public or in private. Another very important provision is Rule 8 sub Rule 5 on case management. Say, except in case provided for in subsection 5, an arbitration claim shall be entered on the court list such that its fair hearing is not later than 30 days after the service of the original motion on the defendant, or in the case of multiple defendants, on the defendant last served. What this means is that arbitration claim in courts are supposed to be given accelerated hearing. It has to be heard within 30 days of service on the defendant. And the reason is very simple. The reason why people go to arbitration is to get their matters heard expeditiously. But after getting it there, and you get to court and you have to queue and also wait for your turn for 1, 2, 3 years, then it will have lost the value and the interest and the reason why parties decided for arbitration in the first place. And that is why this rule now says within 30 days it has to be listed for hearing. Even for appeals, it's also there are provisions in the rules for appeal. For instance, Rule 10 provides, very important, Rule 10, it is no longer the duty of the registrar, either in the High Court or in the Court of Appeal, to prepare record of appeal in arbitration claim. So, my lord, sir, when you have made your order and there is an appeal on it, your registrar will not have anything to do with compiling the record. The procedure for the compilation of record is found in Rule 11. And Rule 11 reads, I will read, says, an appellant shall either simultaneously with filing a notice of appeal on which or within 14 days thereafter, prepare for the use of the justices a record comprising the index, the certified true copies of documents and proceeding which the appellant consider relevant to the appeal, and a certified true copy of the notice of appeal. So it is the appellant who will compile the record, and he must do so within 14 days. That's what Rule 11 provides. And Rule 11 sub Rule 2 there, a respondent, just like in our normal rule, can decide to prepare additional record if he feels that some documents have been left out. It's also important to note Rule 11 sub Rule 3 says, in arbitration appeal, the provision of the Court of Appeal rule and the Supreme Court rule for the time being enforced in relation to the filing of briefs of argument in civil matter shall apply mutatis mutandis upon the filing of the record of appeal under Rule 11. So once it is filed, the rules apply. But not in all cases, as we shall soon see. Case management is Rule 12 when it is on appeal. An arbitration appeal shall be entered on the court list so that its first hearing is not later than 6 months after the filing of the record of appeal under Rule 11. Just like in the High Court, it must be listed, okay, within 30 days. In the Court of Appeal, the appeal must be listed for hearing within 6 months. Within 6 months. So, like I said, it's accelerated hearing in the High Court. It's also accelerated hearing in the Court of Appeal. Another important any problem? So, I want to refer to Rule 15. My time is up, but let me refer to Rule 15. In the normal practice in the High Court and the Court of Appeal on cost is for party to say, on cost, I ask for 5,000 naira, I ask for 10,000 naira, or I ask for 50 or 100,000 naira. It is not so in arbitration claim before your lordship. It is no longer so. The rule as provided for is in Rule 15, and I read it out with your leave. The rules of the High Court or Court of Appeal and the Supreme Court for the time being enforced shall apply in relation to cost in all arbitration claims and arbitration appeal. So, however, the term cost shall include, this is the important area, all expenses actually incurred by the successful party, including its travel expenses and the travel and other expenses of its witnesses, the cost for legal representation of the successful party to the extent that the court or taxing officer considers that such costs are reasonable. So, there will be hearing on costs. That's my own submission. That's the way I look at it. Because in arbitration, we always have hearing on costs. Now, in the arbitration claim before your lordship, there will be hearing on costs, where I will file my claim, what I spend on travel, what I spend on hotel expenses. It will run to several millions of naira. And finally, how powerful these rules can be is provided for in Rule 17. It says, application. The rules of procedure in civil matter for the time enforced in the High Court, Court of Appeal, and the Supreme Court shall apply to arbitration claims and arbitration appeal only in respect of such matter and to such extent as provision has not been expressly made in this rule. So, no one can cite High Court rules, Court of Appeal rules, Supreme Court rules, where the provision is in the third schedule. Thus, ruled in the third schedule supersede other rules of either of the High Court or Court of Appeal or Supreme Court. The rules of High Court, the rules of Court of Appeal, Supreme Court will only apply where there's no provision in the third schedule. I thank you.
Please, another round of applause for Adebayo Adenukwe. We move on quickly to the last presentation, which will be by Dr. Adeyemi Agbelusi. And it will be on finality of awards.
Thank you very much. My lords, let us and all the seniors who are here, I want to stand on the existing protocol and go straight to the point. I'm speaking on section 34, section 56, and section 55, and section 56 of the AMA, which deals with the finality of award. Now, many people have been frustrated with the arbitration process because they believe that the aim of alternate dispute resolution is to avoid the court. And so when you have gone through arbitration, you spend so much money, so much time, and then you get the award, and then it is now challenged, and for 5, 6, 7 years, you are going through the High Court, Court of Appeal, Supreme Court. It's almost as if it's time wasted. So the finality of awards is what I will just talk about, as provided in the Act, but still based on the principle laid by the first speaker, eminent Madam Roberts, that parties must still approach arbitration with good faith. It's something that must be at the back of your mind. I was talking to a Swiss arbitrator once, and he said to me that in Switzerland, when you are going for the publishing of an award for arbitration, you go with your checkbook. Once the award is issued, you pay immediately. Because if you don't pay, the party will simply put your name in the credit bureau, and that affects your credit rating, your bank risk, and you are already being wound up. So it's only in Nigeria that people challenge arbitration and they have almost no consequence. But I think the AMA tries to deal with that, and I'll try to highlight a few of the things that the AMA does, and it's given our own local scenario to deal with it. So, Section 34 is straightforward. It deals with limitation periods. So under the existing limitation law in Nigeria, the time to enforce an arbitration award is a 6-year limitation period. There were ambiguities as to the calculation of this time period. The position of the law in City Engineering Limited versus Federal Housing Authority, the Supreme Court held that the limitation period is calculated from the date of the cause of action. Anyway, the AMA in Section 34 very clearly says that all the time spent in the proceedings basically will be excluded from the counting of this time. So should an award be challenged and is in court for more than the 6 years, it doesn't affect the efficacy of that award. That section is very clear. I want to spend the bulk of my time on Section 55 and especially Section 56. So Section 55 provides for the setting aside of an award, and it gives the grounds for setting aside in Section 55(3), Section 3, that the grounds of legal incapacity, the arbitration agreement not being valid under the law that the parties have subjected it to, failing indication of such Nigerian law, or the party bringing arbitration was not given proper notice of the appointment of arbitrator or of the arbitral proceedings, or was not otherwise allowed to present his case, or that the award deals with disputes not contemplated under the terms of submission to arbitration, or contains decisions on matters beyond the scope of submission to arbitration. If those issues cannot be separated from those submitted, then only the parts that contain decisions on matters not submitted will be set aside. Or the composition of the arbitral tribunal or the proceedings was not in accordance with the agreement of parties, unless that agreement was in conflict with the provision of the Act which parties cannot derogate from, or where there is no agreement between the parties on the above, or if the matter was not capable of settlement under Nigerian law by arbitration or public policy. So basically what he's saying is that under the ACA, misconduct and was a very generic term, whereby you could challenge an award, ask that it be set aside, and the court will definitely have to take a trial to hear what you are trying to say. The tribunal was biased, the arbitration was not fair, and all of that. Now, this act sort of consolidates what the actual grounds for setting aside is. And that Section 55 makes it very clear. So that if you bring any application for setting aside, either in whole or in part, and does not comply with these terms, then, of course, your application is dead on arrival. And this should streamline the recognition and enforcement of arbitration in no small measure. Again, it says that the application must be brought within 90 days or 3 months from the date when the party making the arbitration received the award when it was published, provided that there was no time where, under Section 49, parties that applied for correction of the award, interpretation, or additional award. Now, these three things, correction, interpretation, and additional award, are things that I find that many lawyers do not explore when they get an award they're not comfortable with. So under Section 49, if you get an award, for instance, you have made your claim in Naira or in dollar, and the tribunal had given you an award in Naira, within 30 days of receiving that award, you can remit it back to the tribunal to correct the currency from Naira back to dollar. And the tribunal must return the award back to you within 45 days. So 30, 45. Now, if the decision of the tribunal on an issue is not clear, you can return it within 30 days to the tribunal to make an expansion of the law or the reasoning on that particular part. Interpret that part, not rewrite it, but interpret it properly. Again, within 60 days, it must give you back that interpretation. And then, the most important one is, if you feel that the tribunal has not covered the field, the claimant submitted 3 issues for determination, the respondent submitted 3 issues for determination, which is 6. The tribunal combined issue 1 and 3, issue 2 and 4, and then issued an award based on 4 issues rather than 6. And you feel that, look, that issue number 6 is separate and distinct from the other issues. You should give me an award on it. Then you can remit it back to the tribunal within 30 days, and it will issue an additional award within 60 days. So these are things that lawyers can explore rather than ask for their whole award to be set aside, which is a total waste of money. So this time is not part of the 3 months for you to bring an application to challenge the award. And once you can prove to the court that your grounds are under section covered by what is provided by the law, the court has options also. The first option is that the court can remit the award back to the tribunal for reconsideration in whole or in part. Or the court can set aside the award in whole or in part. And most importantly, and the one I like the most, is section 55(6). The court can give the award back to the tribunal and say, look at it and take any action that you like that will not allow me or move me or eliminate the grounds for me to set aside this award whole or in part. Which means that when I publish an award, I become functious official. But the court now has the power to resuscitate the tribunal and say, take a look at this, Mr. Arbitrator, and eliminate any grounds for me setting aside this award. And if you are furnished with the challenge of the parties as a tribunal, you look at the grounds of the challenge of the parties, you look at your award, and you can take any action, which is really something that will make arbitration, if the practitioners and the lawyers work together, and the courts more efficient. Now, section 56 is the one that many people have wondered about, the award review tribunal. Many people who have criticized it, and I hope I'll be able to publish an article on it, because I think it's the most beautiful gift that the AMA gave to us. But because of our thinking in Nigeria, abuse of court process, everybody feels that I have right of appeal. Even though right of appeal is not a right, but again, I won't go there. I won't go there. But I have to seek leave to appeal. But everybody feels that once I get any kind of judgment or award, I must challenge it as of right, irrespective of its merits. So the award review tribunal says that parties in their arbitration agreement, again, drafting, that Mr. Robert talked about, can put it there that in case of any challenge to this award, it will be referred to an award review tribunal, ART, as opposed to going to the court for setting aside. Now, why will a party do that? Because we're talking about international commercial. When you have, because we don't have big businesses in our jurisdiction That's why we run to court and challenge awards and put all what we are hiding in confidentiality in court. Because if you have competitors who will know your patents, your trademarks, your secrets, your financial capacity, when you have an efficient tax system, I did a mediation last 2 weeks ago of about $19 million between the parties. And if that was not a mediation and it was in court, I'm sure the FIRS will be interested in visiting those parties to know, if you are doing $19 million matter, then how much tax have you paid? So when parties choose ADR, they know what they are doing. Now, if there was somebody who was trying to buy into your company, and then he heard that you have a claim of $19 million against you, if he still wants to buy you, the valuation is zero. And so all of this is not really happening here in terms of mergers, acquisition, competition. That's why people run to court to challenge awards. But where they want to preserve the confidentiality and continue with the process, the ART gives you the room to do so. And I think also the efficiency of arbitration. So when you are not happy and you have put it in your clause, or you both agree to submit to an award review tribunal, then the rules are very clear. The law provides that the tribunal, you will be constituted, the ART, if you had one arbitrator in the first instance, then one. If you had three in the first instance, then three. Once they accept their jurisdiction, their appointment, then the clock starts. Notice of challenge issued to the party. The time frame is specified. You give him the original award, the agreement, and then if it's not in English, you translate it. And then you also put the grounds of the challenge. And once the parties come before the award review tribunal, he will conduct it in any way deemed appropriate. And he will endeavor to deliver his award within 60 days. Which means that the finality of the award is 2 months after his award has been, okay, let's even say you took the whole 90 days before you brought your challenge, then 2 months after. So 5 months later, there's a decision which is final and binding on you. You cannot go anywhere again. It's final. So this makes that award review tribunal very important. And I'm sure that if I know from practice, as an arbitrator, there's absolutely no reason to hear the matter again. Because the documents will speak for themselves. So the proceedings record, all the, if you take the award, the grounds of challenge, it's enough for the award review tribunal to read through it, and either support or dismiss the decision made by the tribunal of the first instance. And once that is done, and the award review tribunal within 60 days endeavor, or maybe 90 days if it's a complex matter, and it gives you that, then it means that the award is ready, ripe for enforcement. And should you go to court to set aside the award, the court may stay proceedings or it may continue proceedings. So that leeway is also given so that it is on a case-by-case basis. Now, when the award review tribunal sets aside the award in whole or in part, a party may also apply to the court for a review of the decision of the award review tribunal. Again, this is under the case management in the third schedule. And where the court finds that the award decision is insupportable, having regard to the grounds on which it has set aside the award, the court may reinstate the award in whole or in part. And where it has affirmed it, then, in other words, if the award review tribunal sets aside some part of the award or the whole award, then you can go to court and ask the court to review what the ART has done, again under time limits. But if the award review tribunal upholds the award, then there's nothing you can do. The only challenge that the court will hear is if, one, the matter was not arbitrable under Nigerian law, which means that maybe it was a tax matter or a family matter, etc., or it's against public policy. So it locks in the finality of the award. The award is more watertight if people understand this process. And I think people should take time to read it properly so that we take the benefit of, one, correction of awards, 2, interpretation of award, 3, asking for additional awards, and then also this award review tribunal will be staffed by mature arbitrators who I'm sure will simply look at these documents only, or maybe just ask the parties to give a short oral address to enumerate whatever arguments they have on the grounds of their challenge. And then within 60 days, he gives you his decision, and then you can go ahead and either recognize or enforce the award. So the whole aim of arbitration is to provide private justice for commercial transactions. Commercial matters are time-bound. They want to save costs. They want to manage expenses. And so the aim of going to arbitration in the first place was because you wanted a decision that is quick and enforceable. There's no point for a party to go to arbitration and as opposed to litigation and then spend years pursuing that action. So the beauty of the AMA with regard to the end product of arbitration, which is the award of the tribunal, is decision as to the issues of determination delivered by the parties. Is final. An introduction of the award review tribunal means that practitioners and legal community can also take benefits of still using the ADR mechanism to complete the process. So in most times when a party gets an award, it will not use the same arbitration counsel to challenge it. You only will give a fresh lawyer with fresh eyes to challenge it. That person can go before a award review tribunal or the court and look at the grounds if it is something that is under the contemplation of the AMA, section 55, section 3, legal capacity, or the arbitration agreement being overstretched by the tribunal, or the relief that was sought not being one of the remedies that the parties are sought before the tribunal. Once we understand all of this, with the underpinning of the arbitration process, then the benefits of having arbitration as an ADR will become something that will attract people to Nigeria. We all know that in 1956, the world adopted the New York Convention for the enforcement and recognition of arbitration awards. But from different jurisdictions, all kinds of awards were coming. So they went and sat down in 1984 and they passed this model law to streamline arbitration processes in countries that adopt the model law, which till today, I think almost 253 countries have adopted it. And they went further to revise that in 2006. And there have been very few changes to that model law. So Nigeria has taken the model law, expanded it, and has suited it to our own native jurisdiction, things that will help us here. But as practitioners, both the bar, the bench, and also the arbitration community, we need to read the act, understand it, and most importantly, in the application of it, realize that cost, efficiency, undue expenses, this process to resolve their disputes. And once we do anything to undermine that, then we are going against the spirit of arbitration. So I hope that all of us will get the full benefits and make plenty of money from arbitration. Thank you very much.
Please, another round of applause for Rev Doc. He has assured us that we'll make plenty of money. Plenty. It's not only plenty. Okay. We now have got to the point where we take questions. Please direct your question to a particular speaker so that they can have your question and respond. If you may also put down your question in a sheet of paper and pass it to the secretary. Okay. Please identify yourself and go straight to your question. No protocol. We can even hear you.
All the countries all over the world has fair hearing as a provisions that can come under public policy. And particularly in Nigeria, Section 36 of our Constitution provide for fair hearing, either by the court or a tribunal. So it is correct to say that an arbitral award in Nigeria can be set aside on the ground of fair hearing under public policy. I've looked at some of the provisions of the Arbitration Act that has to do with procedure. I have a challenge with some on two grounds. There are some provisions of the Act that is in conflict with some provisions of the rules. Then there are some provisions of the Act and the rules that attempts to infringe on the provisions to fair hearing. For an example, Section 9, Section 9, subsection 2 of the Arbitration Act provides that when there is a challenge to an arbitrator, either on the ground of independence or impartiality, that the arbitrator himself that you are challenging shall determine that particular challenge, which will amount to being a judge in your own cause. And we know we have arbitrators that make a living from arbitration. And he has an arbitration that will give him millions of dollars, and you are telling him that he cannot sit over that arbitration. So deciding that case will amount to a breach of the principle of fair hearing. Then if you look at a counterpart provision in the arbitration rules, that is particularly Article 13 sub 4, it says that the person who will determine that issue is either the court, the arbitral institution, or the appointing authority. So there's a conflict. The arbitral rules says that the arbitrator shall not determine it, whereas the Act says that it is the arbitrator that will determine that issue. There's a similar provision again. That is, yes, just the last point. The issue of what happens if an arbitrator is removed. Under the Arbitration Act, it says that when an arbitrator is removed, the party can decide what will happen to proceedings that have transpired before. But when the parties fail to agree, the arbitration shall take a decision. When you have like 3 arbitrators, one has been removed, the other 2 shall take a decision whether to start all over or to continue from where the last arbitrator that was removed stopped. And this again affects the fundamental principle of fair hearing, as decided in Adeleke and Oyetola, which says that the tribunal must be consistent throughout the proceedings. So when you bring a new arbitrator who was not party to the first hearing, it will be set aside on ground of fair hearing.
Talk about the possible to use there's a provision in the law as far as there's a conflict between the substantive and the use substantive provision. It is there in the law, but I can't remember what section of the law. Now, when you ask whether the proceedings will continue, you can't read that provision very well. It is very, very unlikely that if I was sitting on the panel, for example, and one of the arbitrators that will remove the autonomy to decide so many of these things. But in many instances, the tribunal doesn't signal to agree with the parties. If the tribunal says no, the parties have said that the tribunal should go on. The parties, the tribunal can refuse. So that is why I say that when you are choosing your arbitrators, please choose an arbitrator depending on the volume. There's some minor arbitral matters that you can afford to use somebody who is not experienced. But when you are dealing with this state arbitration, please use somebody who can find his brother, who knows what the procedure is. Thank you.
Okay, just to add to it, public policy favoring complaint. The whole procedure itself guarantees fair hearing. So it will be very strange to have a case where an award is challenged on the basis of fair hearing. Because that's why the rules are there. That's why the model law takes it to a system. But on the particular issue you talk about, what we call the principle of competent consent. And the tribunal is capable of those jurisdiction. Also, even the correctness of the contract and the process of itself. Now, what the AMA have done is, in the whole act, it was final. Or maybe because of issues of fairness that you have said. Now, the thing organs to hear, either the appointed authority or the court, is not a confusion. It's simply the appointed authority. So if it was the CIR who appointed the arbitrator, then if the rules are become competent, in 30 days we have appealed to the CIR, not to the court. Because the court who appointed the arbitrator, they will go back to them for the appeal. So that's why you have those authorities there. But if it is not arbitration, and if it is the law, you seek for free with your arbitration. So once you approach an arbitration, you committed with jurisdiction. If it is a challenge at any point, the rules on it, then the AMA allows the president to give your appeal to the appointed authority. And from what Honorable said, the conflict in the rules and the law. And number two, whenever a conflict in arbitration, the substantive law will always apply. But that's very modern law and particular law. The rules are available. In the hammer, the rules are attached. Whether the case is under arbitration, the rules are different. But what you have is simply a situation whereby whatever the appointed authority is basically as you the appointment. That's why you appoint. So there's no short for a call. No failure.
There's a question for Isaiah Bozimo. It says, in a situation where a third-party funder, i.e., a company goes bankrupt before the award is given, is there a way the other party can recover the adverse costs given in his favor? Isaiah, I hope you heard me.
Yes, I did. So, in general, adverse cost, recoverability of adverse cost is a third party point, very interesting. Primarily because the arbitral tribunal only has jurisdiction over the parties. So generally speaking, even if the third party point is solvent, it's helpful to make the adverse cost
Thank you very much. Before taking another question from the floor, this question may interest my Lord the Chief Judge. It says laws are passed to meet specific needs. Laws are passed to meet specific needs. Nigeria needs a medium like arbitration to help decongest her prisons. How possible is that?
I can answer on behalf of my Lord. Criminal matters are not arbitrable. Simple.
Yes, Uthman, Nii.
Yes, Nigeria being a new country.
Can Sulia, can you please sit down?
If you say that an appeal proceeding or an arbitration proceeding must finish within 6 months, and when you have an application to transmit a record of appeal based on an order of the court that the order should be enforced, and it takes 7 years, what do you say to this?
Can't you say it?
My question is that, okay, let me not use. My question is that these beautiful rules,
you mean Schedule 3, the rules?
No, I mean the whole thing. How practicable is it in Nigeria, in a unique country like Nigeria?
Let me ask you a question.
You want to ask a question that aligns with the zone?
No, is that
No, let me take this. You know I'm an old woman. If I remove this wig, you'll see what is going on. Look, you and I make Nigeria. It's as simple as that. That's why anytime we are having this kind of conversation, we have made up our minds that as members of the technical committee, we will start by educating people about the fundamental objectives of the law. If you go to Singapore today, if you go to England today, the way they handle arbitration, we must begin to reorientate our mindset. And I referred to a conversation I had last week. I said, any opportunity I have to talk to students, whether physically or online, I don't miss that opportunity because they are the future of the judiciary. They are the ones going to run the civil justice system in Nigeria. We must begin to tell them that the bad habits that we have taken on board, they should not imbibe it. There is no law that is perfect. I was in England in August, and somebody called me, and we had lunch together, and all he was saying is that they are going to invite me to come and talk to them because they see our law as at the time we were speaking, the most modern and comprehensive law on arbitration worldwide. So whether it works, whether it does not work, depends on us. At the time the law was passed, was signed by the president, I thought our work was done until we held this kind of symposium, and one of the judges got up and said, Mrs. Roberts, I'd like to see you. And he called a couple of us and said, go and do this, this, and this. And that was what led to us going now round another route of ensuring that that Schedule 3, the CJN compels Honorable Justice Yerima and her other heads of court to incorporate it into the practice directions of the courts. And we are making serious effort to lobby. I'm just giving you advance notification that because Onoge did it with Section 55 and said that once you have a matter and you see arbitration clause, it is enforceable, send the parties to arbitration. So whether this works or not is not about Mrs. Roberts. It is not about what is here. It is about you and I. It is about the judges, the counsel who go to court, and because a lawyer used her personal, her firm's letter-headed paper, challenged an award, and then said that, oh, that award, that arbitrator misconducted herself because she used the letter-headed paper. Does that make sense to anybody? But those are the kind of things we see. I don't know whether you understand what I'm saying, sir. So there is no jurisdiction, whether the peculiarity of our country. Who makes the country? Is it not you and I? And I know why you answered that question. And the answer is in this law. We'll have a conversation.
Yes, my chairman.
Of this part. One, the objective of this part is to promote fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. Okay. Now the question is this: assuming the parties have appointed and the arbitral agreement, they appointed the third arbitrator to preside in an institution, and the institution comes around to impose a fee, which is among us huge on the parties before they can kickstart the arbitration. And in view of these rules, what steps will the party be entitled to take?
Thank you very much, sir. And I'm glad you asked that question. There is no doubt that arbitration is expensive. And that is why I say that when you are drafting, there was a paper I presented at the NBA, one of these fora several years ago. When you are drafting your arbitration agreement, please look at the profile of the parties. If you say that the Arbitration and Conciliation Act shall apply, and you leave it at that, you put your parties in trouble. You have a young man who has a startup, who developed an app for a bank, and you put that kind of clause in your agreement between that young startup and UPA, and there's a dispute because they don't want to pay him, that boy is finished. I would not draft a dispute resolution clause that merely is Arbitration and Conciliation Act, because I know that if there's a dispute, if I don't say that that arbitration will be by one arbitrator, it's going to be by 3. And that means the fee of 1 multiplied by 3. So you put a soul, it is there. The parties have the right to determine the number. So that is why I'm saying, please, there are 59 sections of this law that give parties the right. The parties can even determine the fees in the agreement. The fees of the arbitrators shall cover this, this, and this. And one way of doing it is this: each party the party shall bear the cost of the arbitration in equal shares. It is left to the parties to know that, look, if we are bearing the cost, we must, the venue, for example, why do you want the tribunal to go and get a venue that is expensive when we have Oyo State multi-door courthouse venue that is practically free compared to the rooms you hire in Lagos. There is once you go institutional, you have no control over the fees. That is the difference between institutional arbitration and ad hoc arbitration. Let me give you briefly an example. I'm the presiding arbitrator on a 3-man panel. It is an ad hoc arbitration. And I think it's about 11 billion naira claim. And we have a counter claim, everything running to about 30-something billion naira. When we looked at the fees, what I do is I'll ask 3 different or 4 different institutions to give me what their fees are. When we looked at the fees were, in fact, out of this world. And I called my co-arbitrators before we go and meet with the parties. This is not going to fly. This claimant is already impoverished because of the actions of this conglomerate. Can we just be kind to the parties and bring down the fees? By the time we finished dealing with the fees, because we didn't deal with the fees at the first meeting, I said, let all the claims come in. We told them, look, these are the fees that the Attorney General, former Attorney General of Mr. Bozimo will tell you of another incident where I was the presiding and what I did the sole arbitrator and what I did in that instance. Even we are sensitive to such issues. And most times, depending on your arbitrators, they can compromise the fees. But once you are going ICC, once you are going LCIA, you have no control over the fees.
Just quickly align with Mr. Robert, the Chartered ISO arbitrators this year, if you go to our website, ciab.nigeria.org/cost calculator, we published our cost calculator. We reduced our fees by 40%. And then for a 3-man tribunal, we reduced it further by 35%. So if an arbitrator would have earned 10 million naira last year, this year now, you'll be earning about 6 million naira. And with what Robert said, it's very normal in arbitration that parties will normally, when it comes to fees, there's no fighting. They will jointly address the tribunal that, please, this fee is too much. Last week, I sat on arbitration with 3 banks. I was sole arbitrator, 3 banks. And they asked me to my face, can I give them 80% discount on my fees? And I told them, no problem, I will give them 50%. And they were thanking me. Why did I do that? Because like Mr. Robert said, arbitration is really public service. So even though we deserve our fees, because our trainings, our cost is very, very high, but then I don't see any arbitrator who holds on to the fees as if it's a matter of life and death. Most tribunals will give 40, 50, 70% discount just to get the matter going. So please, arbitration is expensive, but that's a myth.
There's this question. In an arbitration proceedings, where the sole arbitrator secured a government appointment and excused himself from the proceedings, can the registrar, who is also a chartered arbitrator or an arbitrator, recommend himself to act as an arbitrator over the said proceedings?
Oh.
None of them will say that, oh, the other party said we should take you because he knows you. It's better to stay out of it.
A question for Bozimo or Adenipekun, will Section 5 of the Act apply to procedures outside arbitration and mediation? For example, a provision to resolve a dispute at the multi-door courthouse or other ADR procedures. Section 5. Section 5.
Section 5 of the Act is stay of proceedings. And there can only be stay of proceeding where there is arbitration clause. Where there is no arbitration clause, nothing to be taken to court to stay.
I observe that the Act does not make provision for specialized courts, but arbitral tribunal. Will specialized courts serve as a catalyst for the development of this Act?
Okay, I think what the person will be asking is, will specialized courts, maybe specialized commercial courts, of course, public justice is cheaper than private justice in any regime. So, but the benefit of arbitration is that parties decide the qualification and the expertise of the tribunal. For instance, I was approached for an appointment recently, and the party said, this clause says that the arbitrator must have good construction arbitration experience. Can you give us a profile showing us that you are so qualified? And so I had to give them that profile. So parties determine that. But if it was a specialized court, then of course the chief judge has to appoint people to go there. So when parties choose arbitration, it's because they want a particular kind of person. So do you have aviation experience? Do you have shipping, maritime experience? Do you have trademark experience? So that in deciding the matter and looking at the claims of the parties, you have that insider knowledge or benefit of your expertise also apply in deciding the dispute.
Isaiah Bozimo, you want to share in this? Thank you very much. We have time for only one more question. 1 minute. Yes, sir.
That you must have initiated an arbitral proceeding before you'll be able to bring an application for the court to stay proceeding. Because I came across a Supreme Court judgment just this July that I'm beginning to think maybe I didn't understand it. They interpreted Section 4 of the former ACA, which is word for word almost, but for subsection 3 of the Section 5 now. And the Supreme Court, their decision, if I understand it well, they seem to be saying that you can't just say there's an arbitral agreement when somebody goes to court and you want to stop it, you have to show that you have actually initiated, because the Supreme Court now drew a comparison. They say it's just like you want to stay execution. You must show that there's a pending appeal. So I'm not thinking, is it me that didn't understand what their lordship are saying, or that if there's an arbitral agreement and the party to that arbitral agreement actually goes to court, if you now as a defendant want to stay it, must you also show the court that you've actually taken steps to arbitrate that matter? Okay, what I mean is that can you just file a motion of notice for a stay when you've not written any communication to initiate arbitration? Thank you, sir.
Under Section 5, you refer to the old law, Section 4, Section 5. You must show that you are ready and willing to go to proceed to arbitration. So I think that's what the Supreme Court was trying to say, that readiness and willingness to undertake that arbitration, you must show it. It's not as if the other side filed a statement of claim, you file your defense, there is a reply, and and suddenly you remember that there is arbitration clause, and you now bring an application and say stay proceeding. The court might not listen to you. So you don't have to file your arbitration. The arbitration proceedings need not have started, but you must show that you are ready and willing to proceed to arbitration. That's what it says.
For example, you would have received notice of arbitration and you ignored it. But if you receive a notice of arbitration and you are to appoint, but before you make your appointment, the other party has rushed to court, you can tell the court, I have 30 days to make my appointment. I have not made the appointment. This man has rushed to court. But you must show a willingness, because if that is not interpreted in that manner, you'll just find people getting the stay and going to sleep. And that is what the Supreme Court is trying to avoid.
I understand we have some questions from those online. Can we take just 3 questions? Okay, we make it 2. So they don't feel disenfranchised. Can we hear them? They sent it. Okay. There's a question here. Where parties are unable to agree to an arbitrator, can Oyo State Multi-Door Court have jurisdiction on that matter?
I don't know what you mean by have jurisdiction. But if in your agreement you have made Oyo State Multi-Door Courthouse the default appointer, then the Multi-Door Courthouse of Oyo State will be the one to appoint for you. Go and read the different categories of default appointers. Oyo State Multi-Door Courthouse is an appointing authority because they have the rights, they have a panel of arbitrators. They will appoint for you. But if you don't make them the default appointer, you can then, it doesn't even have to be the court. One of can submit and say that for the purposes of this appointment, we want it to be the Multi-Door Courthouse. But please go and read those provisions very, very carefully.
I think our time is up, unfortunately. The other questions that were sent online will be given to our presenters at some point and be published by the chapter on our website, if that will solve the problem. The questions are here, but I think we are running late. Our distinguished panelists, I think it's time to ask for announcement and vote of thanks.
Thank you so much. Can we give the panelists a round of applause? A round of applause again. So on behalf of the Chartered Institute of Arbitrators Ibadan chapter, I say thank you very much to the panelists, Mr. Adebayo Adenipekun, SAN, Mrs. Fumi Roberts, Chartered Arbitrator, the moderator, Mr. Obafunsho Ogunkeye, and Dr. Yemi Agbelusi. We thank you. Mr. Isaiah Bozimo, thank you so much. We have gifts for you. I'm expecting to see you at the the conference next week. So I will personally bring your gift to the conference for you. Thank you so much. I'm sure that everybody has had fantastic time learning, and hopefully we will have people who would want to become members of the Chartered Institute of Arbitrators. We have everybody's telephone numbers and emails, so we will send slides to everyone so that you can have all those in the library. We've given out the act and also some of the information about the Chartered Institute as well for people who would like to join. So I thank you very much, and there will be a part 2 of this symposium, and that will be on the 21st of November 2023. That will be in a month's time. We will send out flyers and do the publicity on all the platforms. So we will expect that the hall will be more than full, and expecting everybody. So I thank you very much. And on behalf of my chairman, Mr. Kazim Badamosi, Senior Advocate of Nigeria, the members of the executive of Ibadan Chartered Institute of Arbitrators, we say thank you so much to everyone, and it's been a pleasure having you here. Thank you so much. Pictures before we leave with the chairman and the exco and the members of the panel. Thank you.